We're live.
I appreciate everybody being here. I wanted to mention that evidently the two issues that were unresolved and the reason for the governor's veto was one, the age group that we had put in, I believe it was 22 and under. And the second was the targeted deception. And I think that looking at the definitions and so forth, we need to, hopefully the witnesses can focus on those two areas. I think the rest of the bill is pretty acceptable to all. So the issue of the age group, and I think as we redrafted it, Ben, we put the age at 18 and 19.
Yeah, it's excuse me. For the record, Ben Overgrossi from the Office of Legislative Counsel. It's those under 20 years of age.
Under 20, to be consistent with the raise the age legislation. And so that may be one of the problems that witnesses will cite. And the second is the definition of targeted deception. But if you want to go through the bill, the rest of it is exactly what we passed. And I hadn't heard any concerns necessarily about the rest of it, but.
Take it away. All right. Well, I can do that. And yes, I've already introduced myself. This is S-285, an act relating to law enforcement interrogation policies. And yes, it's very familiar, and it's not just because it's Groundhog Day today. It's because this is as the Senate passed it out last session as S6 with the change of the age to those under 20 years of age. And that was partially in response to the senator's veto, or the governor's veto letter, which I believe you should either have or has been posted, where it was stated that as passed, the bill would make Vermont an outlier by offering expanded protections to young adult offenders up to 22, despite Vermont's already robust constitutional protections. There was uniform testimony in opposition to this bill from the entities charged with promoting public safety, including crime victim services and child advocacy centers, that this bill will remove tools from law enforcement used to investigate very serious violent crimes at a time when our communities are not feeling safe and are asking us to do more. So that's read directly from the veto letter. And then it goes on to state that the bill would make it more difficult to investigate and prosecute young adult perpetrators involved in serious crimes, such as narcotics trafficking, sex offenses, and sexual assaults happening on college campuses, and child sex abuse cases, and internet crimes against children. So those were the reasons that the governor stated for his veto. And what was changed again was the age down from 22 to those under 20. So just to refresh the committee's recollection, Section 1 of the bill amends 13 VSA 5585, which originally was entitled Electronic Recording of Custodial Interrogation. That's still there. It's just moved to another section, and this creates a definition section for the subchapter. And the definitions that are added are deception, government agent, and law enforcement officer. On page 2, you'll see deception is contained in subdivision 2, which starts on line 7. And deception includes the knowing communication of false facts about evidence, the knowing misrepresentation of the accuracy of the facts, the knowing misrepresentation of the law, and the knowing communication of unauthorized statements of leniency. Government agent, definition begins on line 15, would include a school resource or safety officer or an individual acting at the request or direction of a school resource or safety officer or a law enforcement officer. So theoretically that would capture if maybe a school administrator was asked to interrogate someone a certain way by the school resource officer or the law enforcement officer, they would then theoretically fall under this definition. And then law enforcement officer has the same meaning as it does throughout our statutes and as defined in 20 VSA section 23(1)(a). Moving on, you'll see that on page 4, this new section 5586 is created to accommodate the electronic recording requirements that are already in statute. And then on page 6 is really the meat of the bill, which adds section 5587 to Title 33, and this concerns the interrogation of juveniles. So it reads that during a custodial interrogation of a person under 20 years of age relating to the commission of a criminal offense or delinquent act, a law enforcement officer or government agent shall not employ threats, physical harm, or deception. Any admission, confession, or statement, whether written or oral, made by a person under 20 years of age and obtained in violation of subsection A shall be presumed to be involuntary and inadmissible in any proceeding. It goes on to say that the presumption that any such admission, confession, or statement is involuntary and inadmissible may be overcome if the state proves by clear and convincing evidence that 1, the admission, statement, or confession was voluntary and not induced by the officer's or agent's use of threats, physical harm, or deception prohibited by subsection A, and any actions of a law enforcement officer or government agent in violation of subsection A did not undermine the reliability of the person's admission, confession, or statement, and did not create a substantial risk that the person might falsely incriminate themselves. So that's the law. And then section 4 on page 7 mandates the creation of a model interrogation policy. So on or before October of this year, the Vermont Criminal Justice Council, in consultation with the Attorney General, shall collaborate and create a model interrogation policy that applies to all persons subject to various forms of interrogation, including custodial interrogations occurring in a place of detention, custodial interrogations occurring outside of a place of detention, and interrogations that are not considered custodial regardless of location, and the interrogation of individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels. So that's what the policy would have to include. On or before January 1st of next year, the council, in consultation with stakeholders including AHS, the Vermont League of Cities and Towns, the Vermont Human Rights Commission, and the Innocence Project, shall update its policy to establish one cohesive model policy for agencies and constables to adopt, follow, and enforce as part of their own interrogation policy. You'll see on page 8 in section 5, this is contingent on necessary for grant eligibility. Subsection B has been amended that on and after April 1st of 2025, so after that cohesive policy has been updated on the 1st of that year, a law enforcement agency shall be prohibited from receiving grants or other forms of financial assistance if the agency is not in compliance with the requirement to adopt, follow, or enforce the model interrogation policy established by the council. And then you'll see here on section 6, statewide policy interrogation methods. This is added to outline that there are definitions here that custodial interrogation has the same meaning, place of detention has the same meaning, and that the council shall establish a model interrogation policy that applies to all persons with those 4 requirements that I previously had gone over. And this is the statute that really enacts it. So on or before April 1st, every law enforcement agency, every constable exercising law enforcement authority and who's been trained in compliance must adopt, follow, and enforce the interrogation policy that includes each component of the model policy that's adopted by the council, and each law enforcement officer or constable practicing having law enforcement authority shall comply with the provisions of the policy. On or before October 1st of 2025, and every even numbered year thereafter, that should be odd numbered year, I apologize about that. The council, in addition with others, including the AG's office, Human Service, AHS, and the Human Rights Commission, shall review and, if necessary, update the policy. And then in subsection D, you'll see that to encourage fair and consistent interrogation methods statewide, the council, in consultation with the AG, shall review the policies that are required to be adopted to ensure the policies of each law enforcement agency and constable to ensure that they are compliant with the model policy. And if it's found that a policy does not meet each component, there's a time period to basically work with those agencies or constables to get into compliance. And if they still fail to do so, the model policy will become the operative policy for that agency or constable. The council, you'll see on the bottom, must incorporate the provisions of this section into the training it provides. And then on page 11, annually, every law enforcement agency and constable who's trained shall report to the council whether or not they've updated or they've adopted the policy. And the council shall determine as part of its annual certification whether officers have received the training on the interrogation methods required by this section. And then annually on and before July 1st, the council shall report to the House and Senate committees on judiciary regarding which agencies and officers have received training on the interrogation methods. And then the effective dates is that this will go into effect on July 1st of this year, except section 5 and section 6 shall take effect on April 1st, 2025. That coincides with the actual adoption of the policy itself.
So Ben, is really the main change of this went from 22 years old to 20 years old?
Yes.
Okay, thank you. Any other?
Yeah, just a quick question, not this, there's a big difference, but on page 8, line 12, where it states that law enforcement agencies shall be prohibited from receiving grants. We're talking about state of Vermont grants, we're talking about grants that we can't stop them from receiving any federal monies, can we? Or
Yeah, if this is a state law, it affects their eligibility for any grants.
but it doesn't specify that, does it, or does it in your mind? State
Well,
and federal grants?
Yeah, grants would be all inclusive,
All inclusive.
unless you want to make a distinction.
Oh, just asking, just. If that's gonna cover it, that's fine with me.
Anything else? Not seeing anything else in here, Senator Sears?
No, I don't. I'd go back to the focus on the age and the targeted deception, but I will say the grant, I think, follows other bills we've done in recent past, including, I can't remember the names of the bills, but we've done a number of them on traffic stops and other items where we've said if you don't follow the model policy, you're not eligible for grants.
Senator Bohosky.
Thank you. I'm sure it comes as no surprise that I am opposed to lowering the age, given that I advocated strongly last year that this should actually apply to everyone. And if we were going to carve out a group of youth, we should follow the science and it should be under 26. But then since the veto message and since last year, do you know if any other states have, if the landscape has changed at all? My understanding is Minnesota and Connecticut are both working on bills that would ban this practice for everyone. Do you know if there are?
I haven't done that research
Okay.
yet.
I think if we hear, I can't remember his name from the Innocence Project, but he could probably fill us in on the status in other states.
Okay, that would be helpful. Thank you.
Nathaniel, or I can contact you if you'd like.
Perfect.
Thank you for that memory.
Every now and then.
Thank you, Ben. And if there's nothing else, we have Tucker Jones next.
Good morning, Senators.
Morning.
My name's Tucker Jones with the Department of Public Safety. So with S-285, we're picking up where the policymakers left off last year. Before getting to your point, Senator Sears, as to the age and the standard for admissibility, I'll just start with the policy briefly. I just wanted to flag two things. One was, with that policy, there was a recommendation last year, I believe it was from the Department of Public Safety when this was in the House Judiciary, of adding some practitioners who actually do these interviews of suspects to the list of individuals to develop that policy with the council. And so there's just a recommendation there to have them involved with the development of the policy. And we suggested a handful of entities that would represent that cohort. So I'm just flagging that. And as it relates to the policy, I also want to flag that you did have the council in last year to discuss the creation of that policy and their capacity to do it. And there was some discussion of an appropriation there for the council as it related to policy position or what have you. And I'm just flagging that for you to consider talking with the council again on this bill regarding the capacity for the policy.
I thought we put that in the budget, and I'm not sure if it ever made it through.
So, I can speak to that, Senator Sears, if you'd like. Is that, yes, it was put into this bill. It went before Senate Appropriations, and then it was taken out because it was considered that, I don't recall the program, but that there was something already in the works that could potentially assist the council with either funding a position or funding the work to do the policy. So that's why it was removed.
But I'm happy. I think the committee would be happy to consider restoring that if they didn't get the funding from I think it was a federal grant that they were seeking.
And I'll say I know nothing about the circumstances. I'm just flagging to chat with the council at some point on this bill since it tasks them with.
If you get us the language that was used to add people to that group, I'm happy to look at that. I don't remember. That wasn't it? Was it in the House bill?
Yeah, this was in the House, and I can get that language, Senator Sears. That's where a lot of the discussion on this bill really happened, was in the House. As you know, it got out of the Senate. There was kind of new testimony in the House Judiciary on this. There was Detective Ruth Whitney, who spoke on this bill. Detective Sergeant Drew Cota, I believe, spoke on this bill. Matt Raymond, the commander of the Internet Crimes Against Children Task Force, spoke on this bill in the House. There was a memo from the Attorney General's office at one point during the session, and again, I think it was when this was in the House, requesting the removal of the 18 to 21 age range in the bill. They said the Attorney General's office advocates for completely eliminating the age range of 18 to 21 from the bill. Our position is largely due to the importance of confessions and admissions and sexual assaults that happen on college campuses and child sexual abuse cases. So then it came back.
Real quick, Senator Vahovsky wanted to add to this.
Yeah, around the Criminal Justice Council, I think if I recall, the testimony that they gave was not specific to this bill, but largely that they have a lot of this policy development work that they're being tasked to do in all kinds of places, and they can't manage what they have. So I think that was where we thought of adding a whole other policy development position.
Yeah, the way that the language read, if memory serves, is that it was a director of policy that would be responsible for all internal, external, and state mandated policies. Mm-hmm. So it would be all inclusive.
Okay, so I did just want to clarify, it was not just about this bill.
Okay.
Tucker, go ahead.
Sure. So that was in the House, and then it came back, as you know, for the Senate briefly, and there was a conference committee on it with the veto. And then there was another letter after the veto during the veto session last year. It was encouraging legislators not to override the veto. This was from the executive directors of the Children Advocacy Centers and the executive committee of the Department of State's Attorneys and Sheriffs and others. There were 23 people in total that signed that letter. And in part, it said targeted deception is a tool used with suspects in this age range, 18 to 21 age category, to elicit truthful reactions about the suspect's own culpability, helping to identify victims and stop perpetrators of sexual and physical violence. So really, there's a recommendation here from me to hear from these practitioners for your committee in Senate Judiciary. What these letters are saying and what the practitioners clarified, I think, is that there really is a difference between the technique of targeted deception on the one hand and all of the impermissible tactics to pressure and coerce suspects on the other. And that targeted deception is something that's covered by this bill in the definition of deception, because it's the knowing communication of false facts about evidence. So it fits under this definition of deception on page 2, line 7.
Tucker, we have another question from Senator Bohovsky.
Yeah, I have a couple of questions. So given that this bill, one of the concerns I recall coming up was around internet, pretending you're someone you're not on the internet. And my understanding, and this might be a question for Bill or Ben, about the bill, is that because this is only custodial interrogations, this would not apply to that practice.
Right, if it wasn't, if it was just someone on their computer, yeah.
They could continue to be, it could be you pretending to be a 14-year-old girl, and that would not be covered by this bill.
Might be difficult to pass, but yeah.
But on the internet, you can be anyone.
That's true.
My question for you, Tucker, is, are you aware of the over 2 decades of research that shows that this practice is not actually terribly effective in gathering truthful responses and actually greatly increases the rates of false confessions?
And Senator Bohovsky, I think that's where some of the breakdown occurred last session, because I think there is broad consensus among everyone that there are sets of tactics that serve to pressure and coerce suspects, regardless of the age, that are impermissible, ineffective, ill-advised, and result in the suppression of statements by suspects under the existing voluntariness standard. And part of this bill and part of the definition of deception in this bill covers that behavior, those tactics. What the issue is not about any of those pressure and coercion tactics, but rather this specific limited technique of targeted deception that is used by law enforcement in some circumstances and is a helpful tool to elicit truthful reactions by individuals, including in this age range. And that I think is the crux of where communication broke down last session on this, because there is, I really believe, it's not even taught to engage in any of these pressure or coercion tactics, and it is long established in the courts that a lot of these pressure and coercion tactics just instantly render any statements from someone involuntary and inadmissible in court. And there's really no argument about that. There's no dispute. There's no one claiming otherwise. The real question is whether it's a good policy decision to also include into that bucket something that has historically been recognized by the courts in the existing voluntariness analysis as something that is permissible and acceptable. So, and that is what I think was elucidated by the testimony from the practitioners in House Judiciary of what that distinction really is about. The technique of targeted deception, as I mentioned, it's treated differently under the existing voluntariness analysis as compared to all of this impermissible coercive behavior, like promises of leniency, coercive tactics that put pressure on suspects. The courts distinguish between lies about the evidence of the case and all of the threats, improper influence, and physical and psychological pressure that we long know is improper and inappropriate police tactics. And the court says that lies about evidence of the charge, well, this is one of the examples, is in Vermont. The court has said lies about evidence of the charge are more likely to evoke, if any feelings at all, a suspect's belief about his or her own culpability. And so the classic example of targeted deception is in sexual assault cases. including sexual assault cases involving college-age suspects. And so that is suspects between the ages of 18 and 22. Investigators may ask a suspect, for example, did you have sexual contact with the complainant? And the suspect, in a typical scenario, may deny that contact. And then the investigator may state to a suspect that the complainant received a sexual assault exam after the alleged contact, when in fact the investigator knows that the complainant did not do so, and it would be an example of deception under this bill. It is specifically used to elicit a response by the suspect about their own culpability. One of the typical responses would be an acknowledgement of contact after an initial denial, and then a claim that the contact was consensual. And this can be helpful to investigators to move these cases along to understand the truth, what really happened, between these two people. The bill prohibits this technique with college-age students, and it proposes a standard for admissibility that many of the stakeholders last session, including the Department of Public Safety, suggested needs work. We did draft some language. Again, I believe this was what it was in the House, of an improvement to that admissibility standard, but wasn't ultimately taken up. And so we would propose here to kind of resend proposed revised language, senators, on the admissibility standard on page 6, starting at line 14, to address that standard and what we view as some of the concerns with it. And we do that with consultation with the Department of State's attorneys and sheriffs and the Attorney General's office, because they are the ones ultimately that are going to be dealing with this in court. I have an example that I don't think I gave to this committee, but I gave to the House Judiciary Committee on the technique itself of targeted deception in practice. And I'm wondering, I'm looking at the time, and I'm wondering if I just have a few minutes to give you that example from Vermont case laws, senators.
Yeah, we do have 2 more witnesses and about 25 minutes left, and I do want to make sure we get to our 2 other witnesses. So, but if you're able to share.
Well, I won't go into the details of it. I'll just give you the citation then for it. The example in Vermont of the technique itself is in State v. Colts. It's 2018 VT 131. And so that's an example of an adult defendant confessing to aggravated sexual assault of an 11-year-old in response to this technique of targeted deception. And the investigator in that case was actually Detective Ruth Whitney, who spoke with House Judiciary. And so I'd recommend for you senators engaging with this topic of kind of what the boundaries are with targeted deception is, one, to hear from her and get a sense of that case. I could summarize it, but I won't for purposes of time today.
Perhaps we could hear from her, but I think it would be helpful to get a definition from you or somebody in the administration that
Senator Sears, if I can just add real quick, it sounds like Ms. Pullman doesn't need to testify today, or okay. So that does provide more time for Mr. Prince and Tucker, but up to you.
Okay. That's fine with me. I would like 2 things. One is an example of other states that, in terms of their definition of deception, that would be acceptable to the administration. And secondly, having that information. Detective, what was her name? I'm sorry.
That was Detective Ruth Whitney in that particular case, and she spoke in House House Judiciary on this.
We could hear from her at a later date, but I would like to get what is the definition of deception that other states have used and that would be acceptable to the administration.
And there are a few different approaches to it. One suggestion would be to exclude this concept of targeted deception from the definition of deception itself. Another would be to include it, but apply heightened scrutiny of the use of targeted deception to the younger age cohort with what we would suggest is a workable standard of admissibility in those circumstances. There's a few ways to kind of cut the cake here. And we could offer you kind of a unified recommendation of how to do that.
That'd be fun. That's what would be helpful to me personally, just to have something that the 21 signatories. I understand the age is going to be a problem that we're going to have to overcome or not overcome, but the the deception issue is where the second problem lies, and so we're going to have to. Hopefully, we can simplify the whole process by getting to some place where we all understand where we're at.
And so I'll just conclude, as it goes for the age itself, the kind of position that evolved from the Department of Public Safety after speaking with a lot of these practitioners who do these interviews was that we were looking at Utah, Delaware, Illinois, Oregon, Indiana, and California last year, because that was what we had from, I think, the Innocence Project at that time. So the time has passed on what their legislation looked like with age thresholds of all of 18, except California, which had an age threshold of 17. And so we were suggesting consistency with those jurisdictions last year. We'd still recommend that. And really, the reason is because we believed that consistent with those other laws, the existing voluntariness analysis was sufficient and appropriate to cover the age category above that. And that was the department's kind of position then, and it's still the department's position now. So I'll stop there, senators. Thank you for your time this morning.
Thank you, Tucker. Any other questions for Tucker? All right, thank you. Next up, we have Samantha Prince.
Hi, good morning.
Hey, Samantha.
I just want to say thank you to Tucker for what he offered this morning. We appreciate it and would echo many of his sentiments, as you will hear. So I provided some materials for you all this morning, including an open letter from the Vermont Children's Alliance, which is the state chapter here in Vermont that provides support and advocacy to all of the individual child advocacy centers. I provided some educational infographics that I hope you find useful, just because you've heard from us on a prior bill this session, and you'll be hearing from us on a couple of other bills. And I want to sort of paint a broad picture before we delve into 285 that the child advocacy centers have protocols in place, and we follow procedures for interviews and investigations that I think the state of Vermont would find amenable, because the standards are set from the National Children's Advocacy Center, and they're very, very rigorous. So we're already implementing best practice. And so we spoke, I believe it was 2 weeks ago or last week, on S190. In regard to adding hearsay for serious bodily injury, which obviously we were in full support of. We'll also be speaking on some other bills coming up regarding sentencing, the second look, and a few others. And I want to just let you know that where we're coming from is a place of wanting to apply best approach for all investigations at every phase. When it starts first with the interview, and when it proceeds throughout the investigative phase, collecting evidence, and when it gets to court, and when it gets to sentencing. We oversee that whole process as a team. And so we have members that do the interviews, that receive training from the National Children's Advocacy Center, which is an evidence-based modality. That's based on a lot of research. So it's always developing because the more you know, the more you can do. And so as we learn new information, we refresh our training every year, sometimes biannually, however often is really necessary to make sure that our practices and approaches are as good and strong as they can be. That being said, to reiterate some of what Tucker was offering, we spoke on this last year during last session that we are in full support of police reform and having officers have tools at their disposal that are both fruitful to confessions, but also helpful in reducing the overall trauma from engaging with law enforcement. So some folks who are in support of this bill have mentioned that interrogations are at times traumatic, which is undoubtedly true. It is an exhaustive and emotional process. That being said, we are in support of an interview modality that reduces the stress and overall trauma, understanding that people who commit crimes like having sexual engagement with children, trauma can't really be avoided if they confess to that because it is shameful and it is very, very hard to come to terms with acknowledging that as an adult person, you are sexually attracted to children. So it's not something that people are easily willing to say or to share, and we understand that. And so the process for talking through that with someone can be a very long process, which can be very challenging. Most interviews that I've engaged in with alleged perpetrators of sexual crimes against children result in tears from a lot of curious questions, a lot of offered compassion, and frankly, a lot of misrepresentation of personal and other types of beliefs and values. So I've seen a lot of officers engage in conversations with alleged sex offenders that will say things like, well, you just fingered her. You didn't actually have sex with her. Or it's not like you hurt her because there's no injury to the child, when in reality, and you'll see in some of the infographics there, I've put at the bottom of one of them things that are really normal. It's really normal for medical exams to yield normal results. So what Tucker mentioned in the example of saying a sexual assault nurse examination has happened when it hasn't happened, or saying that there was DNA recovered when maybe there wasn't, those examples, and saying that there's injury to a child when maybe there isn't injury, those examples are things that sort of break down the barriers of someone's willingness to concede to the fact that they did engage in sexual behavior with a child. It also offers them the opportunity to show remorse for it. And in that being said, it offers the opportunity for them to start healing. And I understand that from a justice perspective, right? There's this notion that we want everyone to serve sentences, or we want to lock them away and throw away the key, or that they can't be fixed, there's no reform. But the reality is, the more often people are able to be honest about their misgivings or wrongdoings, the better off they're able to move forward, and others are able to move forward as well. The truth is just not something that's typically easily uncovered during the investigative process. I've spoke with police officers throughout the state of Vermont about the frequency of which they are receiving confessions. And as from the folks that I've spoken with, the rate is very, very low. One thing I want to also be clear about while I'm speaking to you is that I actually agree that this being targeted for youth is seemingly unfair. And I would suggest that if we're going to set forward standards for appropriate, healthy, and fruitful interview tactics, that it should be for everyone, because there are many people, including ones that I've spoken with, that were disenfranchised for one reason or another, whether it's a lack of education, a traumatic brain injury, mental illness, developmental disability, etc. To exclude those folks, but to include young adults seems problematic on its face. And I think that the interview techniques that we use for victims can be applied to perpetrators. And the interview process is supportive and exploratory, and it offers people to be able to share their experiences in their own words. So with this bill on its face, we can't support it as it's written. There are also many issues that I've identified in the bill and reviewing it with other CAC directors that we have questions about, and it might be that we have misunderstood. So I would like to review some of those with you, given the folks in the room that might be able to clear that up, because it might change some of our position. I heard earlier when Senator asked.
Samantha, before you get into that list, I'm sorry to interrupt you. It looks like we have a question from Senator Baruth.
Okay.
Thank you, and I think it'll be relatively quick. I'm looking at something just handed to me from Vermont Children's Alliance,
Yes.
a statement on the bill. So I'm wondering, in the last paragraph, it says of the bill, it is unclear, inconsistent, and penalizes the ones doing the work. I'm wondering if you can explain to me how the bill penalizes the ones doing the work.
Yes, is it okay if I address that when I get to that part of the information that I was intending to share? I'm just trying to go through it in a cohesive manner.
Sure, sure.
Okay, thanks so much. And if I miss it, please let me know.
Okay.
What I wanted to address before was that the online undercover operation would be exempt from this bill, if I heard that correctly. But one of the questions that we're raising is that if this bill, with the way that it's written, I think would disable law enforcement from having face-to-face interactions or even phone interactions with folks. If they simply ask, "Are you a police officer?" the officer wouldn't be able to say no in that regard. So whether it's online or in person, no matter the form of context, the officer would have to acknowledge that they were in fact a police officer. Is that correct?
Not necessarily. So the definition of custodial interrogation is one that involves questioning by a law enforcement officer that's reasonably likely to elicit an incriminating response, and in which a reasonable person in the subject's position considered them to be in custody, starting from the moment the person should have been advised of the Miranda rights and ending when the question is concluded. So it's not necessarily just informed by, are you a police officer or not? It's fact dependent, but that's the definition in statute.
If the committee needs to redo the entire bill, then that's a different process than I was expecting as chair of this committee. My goal was to respond to the governor's veto. And I think that to rehash the entire bill is frankly not in the best interest of this committee's time to get to other things that we feel are important as well. And I'm concerned that we're going to reopen the entire bill, and we're not going to have time to do that in this limited session. So I'm wondering. I've tried to talk with people. I've tried to be accommodating, but I think my biggest concern is the targeted deception and the age. And if we can focus on that,
Sure.
The other things were fully vetted in both the House and the Senate. The items that came up during the veto session are directly in response. The items that are in the veto message, are directly responsive to what was in the bill as passed, and no one mentioned other areas. So while I don't want to preclude discussing other changes to the bill, if we're going to do that, I need to schedule much more time for this bill and decide whether or not, what we're going to do. I'm worried that we get into the nuances again when we've already made this policy decisions in many other areas. But happy to hear your comments. I want to keep in mind, though, as we talk about this bill, it talks about its goal is innocence protection. And we know that many people have been convicted through false confessions. And that's what this bill is about. So what if somebody actually didn't do what they're being accused of? And some of the most powerful witnesses I've seen in my 32 years on this committee are people who actually did not commit the crime that they were convicted of and jailed for. And one individual, actually, because he was from Massachusetts, couldn't receive treatment because he refused to admit that he had committed the crime and spent an extra, I think, 8 years in jail, a total of 22, until he was found not guilty through DNA evidence.
I appreciate that. Well,
So that's my perspective only, and but happy to hear from you on. I'd like to focus today on the age and the targeted deception.
No worries. I can definitely adjust. I appreciate it. The age issue for us is also, we said this in last session, that this age range, unfortunately, tends to start to develop these habits prior to becoming 18 years of age. particularly around sex crimes. They would start engaging in sex crimes in their early adolescence usually, and those things become sealed for juvenile record. Then when they become 18, they already have a sense of habits and preferences when it comes to their sexual offenses. And so those things become prolific very quickly. And so looking at this age range particularly and protecting them from targeted deception or misrepresentation of the facts, we view as problematic, because those behaviors and crimes need to be stopped and corrected. And there needs to be the opportunity for these young adults to make those changes, to receive the consequences that they deserve for the crimes that they commit, so that they can have more productive adulthoods. Because this age range specifically is the most vulnerable for having their patterns of behavior cemented in as lifelong tendencies if they're not corrected prior to reaching 25 years of age. So while they're also vulnerable, they're also ripe for change. And so we would encourage this age range to actually be part of a defendant's position where they're more likely to be elicited truthful information. And so this age range we disagree with on its face. The targeted deception, similar to what Tucker had provided, we would really prefer to see a set of standards that are considered permissible before saying law enforcement can't use targeted deception. To remove a tool from law enforcement before offering them alternative means to have good investigations and good interviews with all parties involved would be detrimental to the process, and it would be a massive burden to the justice system in its entirety. I have a few case examples I can share with you where misrepresentation of the facts was used with this age range, and also with a 50-year-old man who had a traumatic brain injury. I do want to be respectful. Yes.
Before you get to that case, Senator Bruce has a quick follow-up for you.
It seems like you're going to be truncating your testimony a little bit. I'm wondering then if you can, before you leave, answer my question about how does this bill penalize the ones doing the work?
Yes, thank you so much. I did forget, and I was not going to remember. I appreciate it. Yes, so to answer your question, it is believed by law enforcement and the people that are doing this work, that are having these conversations, that are interviewing these alleged suspects, that passing this bill as it's currently written would leave an incredible gray area for how they could or couldn't speak with suspects. And that's to say, misrepresenting the facts and misrepresenting the evidence are things that have been commonplace for them for a long time. And so if you're not first offering an alternative tool for them to use, they're going to be left essentially with their hands tied and limited in what they can and can't say. If I asked all of you to come up with a line of questioning for someone that didn't offer any misrepresentation of the facts or information, I think that you also would find it challenging. And that's the feedback that we've gotten from attorneys and law enforcement officers that we've spoken with.
But I would suggest that removing a tool is not the same as penalizing the person who wants to use the tool. It seems to me an overly inflammatory way to describe it, in the way that sometimes judicial reform or police reform are characterized as attacks on police. I don't view this in any way as penalizing officers. It's simply limiting the tools that they can use in order to protect others.
And respectfully, I think that in that regard, we just have very different opinions. I've worked along officers for the last 15 years. I provide trainings to officers. I have a lot of conversations with both brand new officers and senior officers. And what I hear from them time and time again when legislation gets passed down without their input and without their ability to say, that's going to hurt us, is that's exactly the reaction that you get from that community. So I'm not sure if you've had time to familiarize yourself or interview folks that do this work, the law enforcement officers, but to them, passing this bill as it's written without offering an alternative would in fact feel very punitive for them.
I have to disagree with you. Saying that their investigation might be slowed or halted is different from a penalty to that officer. There's nothing in the bill that penalizes police officers.
Okay, I see your point. We could definitely.
I'd like to interject real quick. It sounds like there's a disagreement there, but there is one more question and we have just a few minutes left. And I also want to make sure you have time to conclude, Samantha. So Senator Bohofsky, your question.
So I have too, you're aware that Britain and all of Europe has banned this practice, Britain doing it more than 30 years ago.
I am aware of other countries banning this practice and implementing alternatives, yes.
And you're aware that the rate of child sexual abuse in Britain is less than half the rate here in the United States?
I'm not aware of that, no.
Oh, okay. Well, I think a lot of times things are conflated as we're gonna like send people who are doing this rampantly out into the street, and that is not how it's played out in places that have banned this practice more than 30 years ago. Even the International Police Training Association has said this is bad police practice. It greatly increases the rate of false confessions, which not only means that someone sits behind bars who shouldn't be there, but that the person who's actually doing harm is still out on the streets.
So to be clear, we don't disagree that this needs to be changed. We're asking that there's an alternative offered before this is taken.
Maybe we should hear from the International Police Training Association as to what they would suggest as an alternative and include that in the bill. I'd be certainly open to that.
I think, and that's really what we're asking, is that the section, I think it's 4 or 5, where the mandate is for there to be alternative training, that comes first, because taking this away from officers, and to go back to Senator Baruth, penalized, we could use a different term. I absolutely understand what you're saying about that being inflammatory, and I apologize. I can't think offhand of a term to use in its place, but what I mean to say is that it inhibits the way that these folks would be having these conversations. It would take away their ability to engage in a dialogue with a suspect in a way that would be normal and maybe even practiced to them. And that's not necessarily just targeted deception. That's also the misrepresentation of certain information, because they try to be very strategic about how they talk to people and what they present to people, in the hopes that people will at least admit to parts of the crimes that they have committed, in the hopes that they can make progress for the victims that they're serving.
Samantha, we have about 1 minute left, maybe 30 seconds before we have to head to the floor. We hear the bell ringing.
I'm going to suggest that we have Samantha back to continue this conversation.
I agree.
I don't want to cut her off completely in the middle of that. So Ben will be able to arrange a different time, and I think we've got a few things to think about. I thank you all for your cooperation.
Thank you for your time.
Thank you. We'll see you again soon, I hope.